Minister for her statement. Next speaker is the Honourable Charles Ramson. You have the floor, sir.
Thank you very much, Mr. Speaker. May it please you, I rise to share my contribution on the subject of Public Utilities Commission Bill. I'd made some references in my previous contribution on the Telecommunications Bill as it relates to the role of the PUC and the role of the Telecommunications Agency. Conceptually and ideologically, I think that the PUC ought to function and function exclusively as a complaints commission that executes the decisions of that complaints commission in the way that it is structured correctly here in this bill as a high court would be doing. It ought not to, however, share roles of regulation with the Telecommunications Agency. It ought not to have the Telecommunications Agency set or do a price-setting arrangement and have that power contained in the Telecommunications Act. And then the PUC, on the other limb, deal with changes to price. It should be one regulation, one regulator, and where regulation fails, the consumer ought to have recourse to this commission, which ought to function as a complaints commission for utilities. Why? And why is it important? Public utilities, even if it is privately owned, even where we get to the stage that government has no share in the ownership, whether it's by shares or control, in public utilities, the public demands a high correspondent or expecting obligation on a government that these services are provided in a consistent and reliable and affordable way. And there are many times when, in the provision of those services, you will find that embroglios of some kind or complaints of some kind arise. It is the regulator that ought to be your first port of call that deals with that and deals with that effectively and efficiently. If that fails, this is where conceptually I think that the Public Utilities Commission falls into play as a complaints commission. With all the power, and I think the concept of having the power of a high court is the correct one. And that ought to continue. But having all the power of the high court with orders to be executed in the same way once registered in the Supreme Court of Judicature can be executed in the same way. That is not what happens as a result of this bill or previously. And the opportunity ought to have been taken to not allow the cross-pollination of regulation of the sector. It's too confusing. There's some regulations found in the Telecommunications Bill and Now Act, and then some regulations found here, and there's no need for that. And then you're dealing with, you have to always be conscious about this information, and the purpose that it's serving is a power given to people, to the citizens. And you have to be conscious and be sensitive that they may not have all of the information or access to all of the information all at once or readily. And if you go and ask the people on the street right now, what do you do when you're dealing with an issue of a public utility? And by and large, and the vast majority of people will not say they will go to the Public Utilities Commission. And that's a fact. And if it is solely engaged for that purpose, then that concept, that idea, that understanding, that appreciation will become imbued, and they will know that they can turn here as a solution. And at the end of the day, your delivery of services, public services and utilities matters a lot when it comes to how you're being viewed for governance. So it will matter a lot when it comes to an election. You are politicians. All of us here are politicians. So there is no need for you to have the conflated and convoluted cross-pollination of regulation in the two bills. There's no need for that. The regulation should have come in the telecommunications bill, and the PUC ought to function as a complaints commission with the power, if a decision has been made as a result of a complaint made, an order captured in that decision and enforced in the same ways through the High Court. That's how it should be done. At least that's my view, and if this bill would have been sent to the Select Committee, I would have shared that view with the government. Second, as it relates to the Court of Appeal or the appeal process, the lawyers in this House would be very well au fait with the dilatory dealing with appeals that are filed to the Court of Appeal. I've been in practice for a number of years now, and I've have a lot of exposure to the sector for a very long time. And I will tell you that there are appeals that are lying at the Court of Appeal for years, and it hasn't been heard as yet. And so when you are now going to establish a route of appeal for a person who most of the time are complaining because they have no other means of receiving a remedy, and most times they're impecunious, most times vulnerable, and they need the arm of the state to not only exist, but to represent them, to give them that voice, to act on their behalf. And if the large companies who have a lot of resources, a lot of very well and educated personnel that can use the dilatory nature of the justice sector to delay a decision made by the Commission, then you are in effect leaving the complainant out in the cold. And if you notice, the appeal, even though it gives a time frame as it relates to when the appeal ought to be lodged, if one is going to be lodged, it prescribes a period of 14 days. It gives no correlating period of when the appeal ought to be heard. And you can't expect that you are going to present legislation for a public utilities commission, which essentially its function is consumer-oriented. You can't expect that you're only going to deal with the lodging of the appeal. You've got to deal with a time frame for a decision or the hearing of the appeal. And that's only fair. Sometimes those public utilities, once taken away, it will affect that person, and if they don't get a decision, for a very long time. The company, on the other hand, if they stay the proceedings, they can continue operating as normal for a number of years until that hearing is heard, until a decision is made. So you're not looking at it holistically from the point of view of what is the result. So a time frame ought to have been included for the Chancellor to fix a hearing for the appeal. And I would even suggest, and since the Honorable Attorney General is here, I would even suggest that instead of going to the Court of Appeal, which deals with very complex technical areas many times, areas of law, it should go to the full court. The full court has the capacity to have more than 2 judges. It usually sits in 2 judges, but it can be 3. And I think it can be even up to 5. But the point is, it can properly, this appeal could have been directed to the full court and expeditiously handled. Not long ago, the full court used to sit on every Fridays. Every Fridays. And so the point that I'm making is, had it been lodged, had the appeal been lodged in 14 days, they would have been able to get a hearing within about a month or maybe less. So properly it should have been gone to the full court. And if you're not going to include a provision for a time frame of hearing the appeal, then you're just defeating the whole purpose of a Public Utilities Commission, which essentially the whole role of it is supposed to be to protect the consumer. Protect the consumer because there is an imbalance of arms or an equality of arms. The second point I wanted to make is in relation to the termination of membership, which includes the termination of the chairman who is appointed by the minister. In Section 9D, and before I'm accused of not reading the bill, allow me to read the bill, or this specific provision of the bill, where it says the minister may terminate the appointment of the chairman or any other member for any good and sufficient cause, and it goes on to if guilty of conduct inconsistent with membership of the commission. Those are very loaded words. Guilty of conduct inconsistent. What process do you determine guilt? Second of all, what burden of proof? Guilt is a word that there is a criminal underpinning of it. You have a number of vagaries which can lead to these vicissitudes that inevitably will be unfair. And if you are seen here as this Public Utilities Commission not carrying out the functions of the minister, well, then you can expect that at some stage or the other you will have to submit your resignation or you will be terminated. There isn't the security of tenure that would give a chairman or a member the confidence to be able to fight for that complainant. Because they know that if the company comes and complains to the minister, which I don't have a problem with, if the company comes and complains to the minister, and the minister comes and phones the chairman and says, listen, we know that this thing has been happening. See what we could do for me. I don't want to be... These kinds of gray areas and crossing lines are not unknown to happen. But for a person who is committed to doing or wanting to do that job and do it in the best interest of the people that he has taken an oath, as he is bound to do, to protect, then he may feel reluctant, or there may be a degree of trepidation as to how far he may want to go. The third point that I wanted to make is in relation to Section 50. Section 54, and then Section 55(5). Once again, before I'm accused of not reading the bill, well, let me read the bill so that the minister can know that we've read the bill. The Commission may require the complainant, not being the government, to give security for the costs of the hearing and investigation of the complaint. How could you, in good conscience, where you are vowed, you are elected by this same public, you're vowed to protect them, come here in this honorable assembly and lay over a bill with the provision that the Commission may require him to lodge security for the investigation and the hearing? It is repugnant. It is unacceptable. Most times these persons are seeking assistance because they are impecunious. This never formed part of the previous bill or previous act. And I would dare and challenge the minister, the honorable minister, or any of our advisors to show us that that has been included. And you think that it ends there, Mr. Speaker? It does not. In 55(5). By the way, I just want us to be clear so that there is no response that the Commission may use the word may, or that somebody who speaks after me may cite the word may as being discretionary. The word may has already been given judicial interpretation in the laws of Guyana by the Court of Appeal of this country. In Baird and the Public Service Commission, 2001, WIR, at page 63, it has been given a directory interpretation. I'm saying this to you because you may not have been lawyers. The Honorable Minister's husband is a lawyer, and you can confirm what I'm saying. But the technical advisors may not have been lawyers, or they may not have been practicing attorneys. And so had the bill been sent to select committee, or had we been consulted at any stage leading up to this process, or this point, we would have shared this information. But again, the government has shown its commitment not to work with the People's Progressive Party, and we're hearing their message loud and clear. So this idea of a social cohesion in this country, there's no point to set up a ministry of it. Start working with the opposition. Start working with the People's Progressive Party. We're not looking for ministerial power. We're willing to bide our time. In subsection 5 of section 55, it doesn't end there, where the complainant or complainants have applied for permission to withdraw or settle a complaint referred to in subsection 1, the Commission shall cause a notice thereof to be published at the cost of the complainant and the complainants. You now have to pay for notices to be published, wherever that may be, how much ever that may be. And we just heard the Honorable Minister mention how much money this commission is going to be funded with. percentage, $100 million, whichever company, and you now want the complainant to pay for a notice? How can you feel good about yourselves? Finally, as it relates to the funding of this body, the commission, I have a big problem with the funding coming from the utilities company. This is a public complaint utilities commission. There is no need to take away money from the private companies. That money comes from taxation. It ought to come into the contingency, the consolidated fund, and the Minister of Finance should fund this agency without there being the requirement of the private companies to fund it. Why? It's very simple. There's a concept known as regulatory capture. Regulatory capture is where, in a very old situation, he who pays the piper calls the tune. He who pays the piper calls the tune, and in effect, the regulators end up serving the interest and the economic interest especially of the public utilities or the people who are contributing towards their budget. And this method of funding has been a symptomatic method or position of this government. You find there being a very cozy relationship with contractors and business people all around the country. Ministers walking into Pegasus with other contractors, spending and drinking all night. Too cozy of a relationship.
Honourable member. I must require you to stay with the merits of the bill and leave the externals for outside of the House. I must require you to do that. Thank you. Please proceed.
The biggest concern that I have in relation to funding is that if the Public Utilities Commission is aware and knows that its financial existence and operation will be funded by the same people that they're required to regulate, investigate, make decisions on, that there is an inherent conflict of interest and a reluctance to be fair and equitable. And in these commissions, that is of most significance. And let me say, if the argument is going to be made that an arrangement of a similar nature is what transpired before, let me give a little bit of background so that we can understand how things can never stay how things can never stay the same. In the telecommunications bill, which we just debated, the reason why companies were given in a very long time ago, in 1934, AT&T had a monopoly for telecommunications service for the entire America. Wireless service, land, whatever it is, they had it for the entire America, one company. Conceptually, it was the belief then that a single company having that monopoly will go and invest because they know that they can secure the ability to reap the profits as a result. Unfortunately, by the end of the 70s or so, that concept had changed. And in 1996, you ended up with a new Telecoms Act. If it is the case that in the Public Utilities Commission bill, which is about to be repealed, that the arrangement existed. No, there is a Public Utilities Act. All right, don't talk to me. In the Public Utilities Act, if the arrangement existed as it relates to funding, and funding came either some or all from a percentage of the utilities company, there is no reason to maintain the existence of that construct now, especially when you are aware, and I am advocating and advancing the reason why it ought not to exist. And it is a logical and more than likely possible consequence. And let's say it doesn't happen all the time. But one time is too much. One single time is too much. And there is no denial that that conflict is an inherent conflict and will deliberately, or I shouldn't say deliberately, directly or indirectly affect the proper execution of the functioning and the judgment of the personnel that occupies those positions. This is not about politics. This Public Utilities Commission is not about politics. This is about making sure that our job here to serve the people of this nation, but more importantly, the most vulnerable people of this nation, the ones that need our help the most, are the ones that get our unbiased and impartial, concerted effort to work together to move that cause forward. And if these changes that I have made are not accepted or at least considered at the stage of select committee, we will not be doing and executing our function effectively, and we will be betraying the very confidence that has been reposed in us by the voters of this country and the citizens of Guyana. And I will warn you that sometimes when you betray people, trust sometimes lost can never be regained. Thank you.